judgment in the appeal in the matter of KL, a child.
The Hague Convention on the Civil Aspects of International Child Abduction establishes procedures for the prompt return of children who have been wrongfully removed or kept away from the country of their habitual residence. If a judge in this country makes an order for a child's return, there can only be an appeal with the permission of the judge or the Court of Appeal, which is only given if the appeal has a real prospect of success. The order is usually stayed until the appeal is decided, but because the appeal is expedited, the return of the child will still be quite swift if the appeal is dismissed. However, in many countries, including the United States of America, there is an automatic right of appeal, and such appeals are not always expedited. Granting a stay would therefore prejudice the swift return of the child in those cases where the appeal should not succeed, and so stays are not automatic. But what is to happen if a return order is made, there is no stay, and so the order is implemented, but it is later overturned on appeal? That is what happened here. The child K was born in Texas in 2006 and is a United States citizen. His parents are both of Ghanaian heritage, but his father is a US citizen serving in the US Air Force. His mother came here as a child and has indefinite leave to remain here. The parents married in Texas, and their matrimonial home was in Texas until the marriage broke down in 2008. The father began divorce proceedings in the Texan court, but was then posted to Afghanistan. So the parents agreed that the mother would look after the child while the father was away. In July 2008, the mother brought the child to London, initially without the father's consent. The father's tour of duty ended in late 2009. In 2010, the Texan court held a full welfare-based hearing about where the child should live, and the judge determined that it would be in his best interests to live with his father, having contact with his mother, principally because the father was the parent most likely to promote Kay's relationship with both his parents. Kay therefore lived with his father in Texas from March 2010 until August 2011. Then, the mother applied to the United States Federal District Court for an order under the Hague Convention, alleging that Kay was habitually resident in England in March 2010, and that by acting under the Texan court order, the father was wrongfully retaining him in Texas. In a decision described by the English Court of Appeal as bizarre, the district court accepted that argument and ordered Kay's immediate return to his mother, whereupon they came back to London and have lived here ever since. The father appealed against that order. Eventually, in July 2012, the US Court of Appeals for the Fifth Circuit allowed his appeal, and on the 29th of August 2012, the district court orders Kay's return to the United States. The father then brought proceedings here, alleging firstly that the mother's retention of Kay here was wrongful because Kay was still habitually resident in the United States, and secondly, that in the circumstances, the court should exercise its inherent jurisdiction over children who are habitually resident or present here to send him back to the United States. The trial judge and the Court of Appeal dismissed the father's claims, but the Supreme Court unanimously allows his appeal and orders the return of Kay to the United States on the basis of undertakings offered by the father, which should enable the parents to share the care of Kay in Texas, pending the hearing of any application the mother may make to modify the order of March 2010, should she choose to return to Texas with the child. As to the child's habitual residence, the United Kingdom applies the concept of habitual residence adopted by the Court of Justice of the European Union, namely that it is a question of fact, and refers to the place which reflects, quote, some degree of integration of the child in a family and social environment, end quote. Parental intention plays a part in explaining the reasons for a child's stay in a particular country, which has to be factored in with all the other factors for deciding whether a move from one country to another has a sufficient degree of stability to amount to a change of habitual residence. In this case, the move with the mother in August 2011 was intended by her to be permanent, and neither she nor Kay will have perceived it to be temporary. Kay had become integrated in a social and family environment here, and so the judge had been entitled to hold that he was habitually resident here by the time the US court ordered his return. However, the High Court still has power to order the return of a child so that his future can be decided in a foreign court, if in all the circumstances this is in his best interests. In this case, the choice is not between staying here with his mother and returning to the United States to live with his father. The choice is between staying here to have the dispute between his parents decided here and returning to the United States so that the dispute can be decided there. In favour of staying here is that he's been here for over 2 years, is at school and apparently doing well there. In favour of returning to the United States is that he was born there, he has a large extended family living there, and has spent half his life living there. But the crucial factor is that he is a Texan child who is currently denied a proper opportunity of developing a relationship with his father and with his country of birth. While conflicting orders remain in force, he will not be allowed to visit the United States and his family there. The best opportunity of enabling him to establish a proper relationship with both his parents and with every aspect of his heritage is for him to return to the United States for his future to be decided there. The parents were invited to agree the terms of an order which would enable this to happen in the light of our judgment, and they are much to be congratulated for having done so.